Daniel. Our next speaker is advocate היבה חוסייני. יש לה גם מצגת להיבה. You also have a presentation?
Yes, I can do that.
Okay. No, come here. Hiba, I call her Hiba because I know her also from the negotiations. But advocate היבה חוסייני is is a managing partner in a Jerusalem-based law firm.
Ramallah-based.
In Ramallah-based.
I wish I were licensed in Israel.
Okay, so it's in Ramallah.
Hebrew, so I cannot.
So in Ramallah-based, she's a U.S. Graduated attorney. She has practiced law in Washington, D.C., and since 1994 has been a legal advisor and practitioner in Palestine and Ramallah. Ms. Husseini has served as a legal advisor to the peace talks between Palestine or the Palestinian delegation, as we would term it. That was one of our each one kept their terminology, and Israel since 1994 until the present. And she also serves on several boards of institutions and organizations, and she will talk about the implementation of the Oslo Accords under international law.
Thank you. It's a pleasure to be here with you this afternoon. I have not been to Tel Aviv in a long time, so it was quite a drive today. But I seem to also have missed a very interesting set of sessions this morning. Nonetheless, I will try to summarize my points within the context, from of course, a Palestinian perspective, and share with you how we have what our expectations have been, how we have approached the peace process, and how we figured the role of international law in the negotiations, and to what extent it was excluded from the negotiations. And I conclude with the fact that it is very relevant if we are to have a subset of successful negotiations going forward. So let me start with just to also time myself so that I'm not over the limit. Of course, as you've heard also from my colleagues here, we did start, and even the terminology, the interpretation, we did start from different points of departure towards the end of the conflict and the end of occupation. The question is, whether was it from a Palestinian perspective, was it an end game, or did we engage in a process of a transition? Obviously, there we had differences between us and the Israeli position. Of course, the balance of power was lacking. There was no symmetry in the negotiating positions for all the reasons that were mentioned and others. And of course, we didn't have symmetrical powers, no reciprocity. And most of all, we did not have as a Palestinian, obviously, the PLO did not have physical presence, nor did it have control over the territory, obviously, and all that goes along with it in terms of air, land, sea, and natural resources. So the diverging positions that we started from were very, very different. That did not enable us, as Pina put it, to frame the issues properly, and we did not have all the legitimacy that we needed to engage fully. Further, obviously, Israel has been a sovereign state, and we have been an organization and continue to be so. Now the statehood issue is another context which I will not get into. Expectations of the parties, we really got into it, maybe naively so, as people and as leadership, that the resolution of the conflict was attainable and within a relatively reasonable period of time, short. And we were hoping to attain the permanency of it. Instead, we somehow were dragged into it and allowed ourselves, again, due to the reasons that I mentioned to start with, into a gradualism process. Obviously, that's from our perspective, that served the Israeli interests, not the Palestinian interest in that respect. Gradualism also meant that we have not dealt with the core issues, Jerusalem, settlements, refugees, borders, and so forth. In terms of a legal framework, the bilateral approach between a sovereign state and an organization that didn't have control over the land, nor the resources, nor even its population, and continued to be fragmented inside and outside the territories, did not allow us to have the international legal framework that we were aspiring to have. The DOP did, the Declaration of Principles did mention or made reference, obviously, to the UN Security Council resolutions 242 and 338, but beyond that, there was no context for international law. Just by way of example, to show you how we regressed from those two resolutions, in 1997, the Hebron Protocol did not even refer to the resolutions. So it was gradualism, lack of parity, and so forth, led us continuously into a regressive process in terms of our the bilateral discussions and negotiations. I list the agreements. Of course, I'm not going to go all of them, but I just want to remind us in terms of their the titles. All the titles are Declarations of Principles, Gaza Strip, Jericho area, temporary, preparatory, transfer of some powers, additional powers, so and so forth and so on. So and the list goes on and on and on and on. I won't belabor that, obviously, but just to demonstrate that it is so transitional, lacks permanency, and it didn't serve our interests at all. Yet we continue to be engaged in this bilateral process without defining the end game and without defining the real interests. Even the proximity talks were proximity talks. I mean, they did not lead us to anything more permanent. From my perspective, and definitely many in Palestine share, and some perhaps even in Israel, these agreements or accords, again, because they're so declaratory in nature, they remain soft, non-binding, and they didn't have dispute resolution. This is chopped off right there. They didn't have dispute resolution mechanisms, nor enforcement and real implementation guidelines. On international law, Israel wanted to maintain a strictly political stance that, again, gave it the upper hand in terms of its interest. We continued to maintain some adherence to international law, yet we did not fully utilize it, nor were even able to engage at that level with the Israeli side, because there was a flat rejection of international rules, norms, because we felt they would empower us. We do insist on them. We do refer to them. We discuss them, but they are not written into the agreement. Open-endedness, also the nature of the agreements have remained open-ended, which goes hand in hand with gradualism, and unfortunately from our perspective, obviously serving Israeli interests, not ours, the open-endedness became the norm rather and the rule, and therefore it was very difficult to go back and to set the stage and the tone for our own interests. Yeah, of course. I mean, when you have open-endedness, you don't have clear. The motives of the parties will remain unclear. This created bad faith rather than good faith, and because the major concessions expected to have been made were not made, there was the implementation was lax. The parties, Israel, Palestine, or Israelis, Palestinians, whichever your perspective is, did not fear to violate the agreements or the accords. So they had no gains that they feared to lose, basically, because of that. Of course, it's facilitated the gradualism and open-endedness of them facilitated development of extreme positions on both sides, thus sapping further the legitimacy of the entire process. The end of conflict was farther and farther away and far-fetched, so the people lacked the trust in their negotiators, and the positive persuasion capacities of the negotiators was lacking as a result, or became hindered. Just by way of example, in terms of making this a bit more concrete, the lack of because we were not able to engage in a very concrete set of agreements. The Israelis, for example, increased the settler population of the West Bank, excluding the East Jerusalem side, by almost 100% between 93 and 2000. So that is an example of how gradualism and open-endedness served Israeli interests. I give another example, which is how, again, a gradualism with the roadmap, and although this agreement, the roadmap, contained provisions that were firmer than the Oslo Accords themselves, nevertheless, it was an open-ended arrangement, an agreement, and therefore its implementation remained gradual, transitional, and without the enforcement powers, without the implementation powers, they did not achieve the results. The same issue in terms of the concept of constructive gradualism, constructive ambiguity. We have gradualism and open-endedness as a characteristic of the agreements, and we also have the constructive ambiguity notion. Again, that serves, in this particular subset of agreements, serve the Israeli interest more than the Palestinian interest. Although sometimes constructive ambiguity does serve the interests of both parties, because that can create room for or a foundation for continued negotiations. It gives you flexibility. It does on a psychological level back home when you address your public. It gives you the sense of that you can claim victory and so forth and so on. And it also, with the difficult issues, gives you some options without really without having to make the concessions too quickly. Nevertheless, notwithstanding these advantages, there are risks, and in my opinion, the risks have been greater, because you can violate. Am I doing this one? Okay. You can, as parties, you can violate them with ease, with greater ease. You think you have resolved the issues, but you really have not dealt with them. Again, with the same concept, it plays for you and against you with the psychology of being at home in terms of how you address the issues. We also, because of the risks that are involved with the constructive ambiguity notion, from our perspective as Palestinians, and because we don't have the upper hand and we don't have the same parity, obviously, we were constantly looking for the third party to play a role and a function. And we can differ on the definition of the third party and their, to what extent they get involved and so forth and so on. But we felt that would create a less biased, a bilateral subset of negotiation in terms of the process. I also moved to another issue, which is the interpretation of the accords or the agreements. We can see from the implementation how the parties interpreted the agreements differently because the expectations were different and their points of departures were different. And therefore, it was allowed the parties again to interpret and misinterpret, and then this created a great deal of distrust between them. I mean, I give examples in terms of how things deteriorated because of the interpretation, because of the disagreement, because of the lack of parity, how the situation deteriorated, how the number of settlements increased, and so forth and so on. And I'm sure many of you are aware of the data and the numbers, so I won't go through that. For the sake of time, I think in terms of let me move on. This is too detailed. Okay. 7 minutes. Oh, very good. I could have belabored it then, but I mean, let me get into the international law from our perspective. What would it have done for us, and why did we insist on it, although we didn't get it? The notion that the cardinal rule of international law is that it prohibits the parties to break the agreements. Obviously, that would have been one principle that we would have liked to have in the agreements. The principle of good faith of international law, to negotiate in good faith, to interpret in good faith, and to perform obligations in good faith. That would have been something that would have empowered us in the negotiations more and more, and would have allowed us to perhaps negotiate even better bilaterally. I mean, that's what I'm really arguing here. Again, I mean, I think I mentioned that, but just because the agreements ignored the entire body of international law, and we simply stuck to two resolutions which we departed from, and because the interpretation of these two resolutions did not allow us to interpret them, implement them, and to negotiate their details in good faith. I'm not saying it was bad faith, but I'm saying the interests of the parties diverged, and the interests of the parties did not meet. Because we did not rely on international law, there were gaps in the agreements, there were inefficiencies in the agreements, we did not frame the issues properly, we did not have the objective standards and criteria and fairness criteria that international law offers or provides, and therefore the trade-offs were not very concrete. They continue to be obviously there. Dispute resolution was definitely missing, and this has been for us a very serious issue because we did not have any form of remedy or redress of the violations and the breaches. Obviously, the same can be argued by the Israeli side vis-a-vis the Palestinian breaches and so forth and so on. Compliance and enforcement, again, were not provided for, and therefore those would have provided a better pretext, a more objective pretext. I also argue that if we had those principles of international law available and more embedded within the agreements, we would have been able to bargain better. It would have, I advocate that we would have had greater bargaining powers because we would have understood better the function of international law and its applicability. So perhaps it would have gotten us, when we used gradualism and open-endedness and constructive ambiguity, would have done it in a more constructive way rather than such an oblique way. I use a case study, which is the settlements, obviously, and how the application of how Israel also moved its position somewhat, but of course not concretely and not in terms of implementation. When we placed the settlements as part of the permanent status, it was just left as a statement, again, constructive ambiguity. Israel in the negotiations resisted making the Fourth Geneva Convention an explicit part of the negotiations, obviously for the reasons that Professor Gross mentioned. Although the settlements violate Article 49, Paragraph 6 of the Fourth Geneva Convention, and the settlements also are against the spirit of Article 2, Paragraph 4 of the UN Charter. And internationally also, there's support for the Palestinian position in that the settlements are illegal. Even the US deems them to be illegal. However, we had a schism when we entered the negotiations in terms of our perspective on it. How do we frame the issue here? Is it part of borders? Is it part of Jerusalem? Is it part of exchange of territory? I mean, how do you set the issue up in terms of framing? So the point is, if we had defined them from the outset where they are within the context of international law would have provided the objective criteria and context and may have allowed the negotiators to move forward on the issue of settlements. Again, I mean, I offer that slowly there's been a slight shift, again, not concretely, not implementation, and not obviously widespread in Israel, but land swaps would be feasible. So that is certainly a shift from the set position of Israel that they're not illegal, We can term the exchange as a land swap rather than call it a legal settlement. But again, and I believe that the reason Israel has moved somewhat in terms of its not necessarily policies, but in terms of its outlook on the issue, is that there's no consensus, or there is consensus worldwide that the settlements are illegal. Okay, in conclusion, I offer to share with you that we believe, or I believe, that the role of international law must be incorporated, and the UN resolutions must be used as a reference, and to a far greater extent, obviously, than 242 and 338. The references and the reliance on international law principles should be able to provide us with a clearer framework and allow us to agree on a more coherent, objective criteria for dealing with the difficult issues and with dealing with issues related to Jerusalem, the settlements, and the refugees. Obviously, we didn't get into all of these issues, but I mean, there's a whole body of international law on refugees and so forth and so on. It's important to have a timeline in order for us to engage productively in the negotiations. Notwithstanding implementation over a period of time, I think the negotiations should be inclusive of all the issues, rather than have issues, as I said at the outset, postponed till later and so forth and so on. That creates a lot of distrust and mistrust and lack of confidence and delegitimizes the leadership, especially on our sides. We may differ. We may differ on the efficacy of international law. We may differ on their norms and their applicability and so forth and so on, but at least, in my opinion, and many in Palestine share this, they provide standards, objectives, and they allow us, perhaps, because we tried the other options, and they have not worked. So now we should perhaps rethink our approach and have a more concrete set of rules that we rely on. Thank you for listening.